This evening, we'll be hearing an address from Madeline Gleeson, a lawyer and senior research associate at the Kaldor Centre for International Refugee Law at the University of New South Wales. Madeline specialises in international human rights and refugee law and refugee protection in the Asia-Pacific region. She has extensive experience working with forcibly displaced people around the world. Tonight, she'll be presenting the findings of a review by the Kaldor Centre of Australia's offshore refugee processing, which has been in practice now on and off for many years, particularly in Nauru and Papua New Guinea, and which is now attracting political interest from other countries such as Denmark and the United Kingdom. My sense is that what Madeline has to say about the way in which this policy has worked will not be much in its favour. Over to you, Madeline.
Thank you very much, Ian, and thank you to the Australian Institute of International Affairs for inviting me here this evening to speak to some findings from some recent research from the Kaldor Centre. If I just share my screen, there's a slide here. The title of our report was Cruel, Costly and Ineffective, the Failure of Offshore Processing in Australia. So as you've rightly noted, Ian, it's not unclear where our findings lay in terms of this policy and its success or failure as a key component of Australia's immigration policy. Before I get into the policy and our concerns with it, I thought it might be helpful to reflect momentarily on what offshore processing actually is. And as I'll return to again later, you'll see that this is because when we refer to offshore processing, many people can conflate it with other aspects of Australian immigration policy. And if we're going to reflect upon and determine whether or not this is successful policy, we need to understand specifically what we're talking about and separate it, differentiate it from other related or unrelated components. So offshore processing is the name given to the policy whereby people who approach Australia in boats for the purpose of seeking asylum are either intercepted or rescued. They are first all brought to Australia. So every single person subject to this policy has touched foot on Australian soil, has been detained here, has been screened. Usually this occurred in Christmas Island. And then at a later period, be transferred by Australian authorities from Australian territory to one of two locations. The first, and the one you can see in the far right-hand corner there, is Nauru, the Republic of Nauru. It's a very small Pacific island state. And there were what's called regional processing centres or detention centres located in the centre of Nauru in a high elevated area that was formerly a phosphate mine, a barren, inhospitable landscape and a very difficult place for a detention centre. And I mean that mainly for the people detained there, but even for those working there, that was a very difficult physical location in Nauru. The second detention centre was located on Manus Island, or part of Manus province, which is in Papua New Guinea. And it's a remote part of Papua New Guinea. You can see at the top of the screen there where the Manus Regional Processing Centre is marked. You'll see that is quite some way from Port Moresby, which is noted on the map further down. That's the capital of Papua New Guinea and much closer to Australia. So if we look at where the Manus Detention Centre was and the Nauru detention centres, we're talking very remote locations in the Pacific. So asylum seekers were transferred to these two places where they were detained, and then their claims for asylum were processed. At different times, processing was done by different states and different officials, but certainly since 2012, we could say that it's been a joint endeavour between Australia and each of those countries, with Australia playing the dominant role by reason of the fact that Australia has the most experience in refugee status determination. So people were detained in these places while they waited for their claims to be processed. And then the big question was, what happened to those who were found to be refugees? And I'll touch on that again throughout this talk. It's important to note that when I'm talking about offshore processing, and I'll touch on this again later, people were only transferred to these places between 2012 and 2014. So while this is a policy which remains on foot in the sense that those people are still waiting for a resolution of their status, this is not something that we have been continually pursuing since 2012. The last transfers happened in 2014, and as I'll explain later, we really characterize the period from 2014 onwards as a prolonged extraction or a phased withdrawal from this policy. So that's offshore processing. I wanted to reflect on why we've done this research and why now. As I've just mentioned, we haven't sent people offshore since 2014. This is a policy that is being wound down. So why does it warrant special treatment in one of the Kaldor Centre's policy briefs in 2021? Well, the Kaldor Centre and the Kaldor Centre researchers have been working on offshore processing in various ways for 20 years. And for a long time, particularly more recently, we've held a grave concern about ongoing myths and misconceptions regarding this policy, the way it's being communicated, the way it's understood. And despite all of the work that's been done by us and others and the many publications, there remains certain misunderstandings about this policy, which we feel remain to be debunked. And the way in which we approached this research was with a strong desire to challenge entrenched positions and divisions. And by doing so, by approaching the issue in a new way. So in Australia, refugee and immigration policy, and this policy in particular, can be one on which there are very firmly held views. And often there might be a misconception that, because I have this broader view on immigration, or because I have this broader view on refugee policy generally, then I must be in favour of or contrary to offshore processing. But what we hope to do in this policy brief is sort of not just cover the same ground in terms of identifying the very real legal and humanitarian concerns, but also trying to approach it as a policy and assess it on that ground. In terms of why now, it is the 9-year anniversary of the reintroduction of this policy, which took place in August 2012. And we've got that eye on that 10-year mark. It's also the 20-year anniversary of the first introduction of this policy in September 2001. So we would argue that any policy warrants annual review, at least, to assess how it's going, to measure it by reference to its stated policy objectives. So every anniversary should be providing an opportunity to reflect on how we're going. But there is particular urgency this year because, as Ian mentions, there is this growing interest in this policy in international jurisdictions. And that's not something that we've seen before. To be clear, Australia is exceptional in its pursuit of this policy. And as I've said, we only really pursued it for those 2 years, 2012 to 2014. But in pursuing it for those 2 years and in sort of maintaining it on foot for almost a decade now, we really stand out in international practice. Other states don't do what we do until now. Now we have the United Kingdom and Denmark in particular exploring ways that they themselves might introduce a comparable policy. So it's never been more important for us to dig into this policy and identify some of its concerns. The way we approached this task, as I mentioned, was not to rehash the well-covered ground on the legal and humanitarian concerns, but to approach it as a policy assessment. What were the stated policy objectives of this policy, and has it met those objectives? This is a policy which has been implemented, maintained, and expanded by governments from both Labor and the coalition. So there have been many different governments that have come through and have continued this policy, but there is consistency in the stated policy objectives. Despite the changes of government, there is this consistency and returning to 3 core messages. Those 3 messages are, first, that this policy is meant to stop boats or deter irregular maritime migration. Second, it is meant to save lives at sea, the drowning which corresponds with asylum seekers trying to reach Australia by boat. And the third is that it's intended to, as it's called, break the business model of people smugglers. So having identified these as the three policy objectives that governments across the spectrum have sought to pursue, we then proceeded to unpack it, look at the data and see has it succeeded or failed in doing so. There are important differences in offshore processing as implemented the first time around, which was 2001 to 2008, and the second time around since 2012. These differences relate to, amongst other things, who was conducting refugee status determination and what happened to people once found to be refugees. So they weren't minor differences at the edge of the policy. They really went to the core of the policy. And since it is the policy since 2012, which has been looked at elsewhere, we focused in our research on the policy since 2012. Within that time, since 2012, we then further broke the policy into these four distinct phases, which you can see on the slide here. And there was a reason for doing so. The reason is that if we are going to reflect on whether the policy meets those three stated policy objectives, stopping boats, saving lives at sea, and breaking the business model of people smugglers, we need to identify the fact that there were shifts in the policy settings and see whether any of those objectives were perhaps achieved in one policy setting but not in another. Our conclusion, as I'll speak to in a moment, was that none of the three policy objectives were achieved in any of the four phases. So briefly to touch on the four phases, the first was between the 13th of August 2012 and the 18th of July 2013, a period when the Gillard Labor Government was in power and reintroduced this policy with what was called a no advantage policy, which claimed that anybody sent offshore to Nauru or Papua New Guinea who was subsequently found to be a refugee would be permitted to settle back in Australia, but would need to wait offshore for as long as they would have waited had they stayed in Southeast Asia and applied to come to Australia through a different pathway. The second phase stretched from the 19th of July until September 2013, and that was when Kevin Rudd came back in as Prime Minister, and he oversaw a shift in the policy to no resettlement. And what that meant was, even if someone was found to be a refugee offshore, they would never be permitted to settle in Australia. Never, no matter how long they waited, no matter if they had immediate family members in Australia, no matter if there was compassionate circumstances, on no grounds would they be able to settle in Australia. However, there was no alternative of where they would go otherwise. So really we can pinpoint from this second phase began the real problem with this policy. Because from this time we said, you can't come here, but we don't know where else you're going to go either. And so began a mad scramble to try to find international partners who would take these people who should otherwise have come to Australia and who under the Howard government, the first time around, had come to Australia in large part. The third phase of the policy, from when the Abbott coalition government came into power in September 2013 until about midway 2014, saw offshore processing operating alongside Operation Sovereign Borders. Operation Sovereign Borders, or OSB, is the policy of intercepting and turning back boats at sea. So that sort of naval ring of steel, which the government sought to establish around Australia. And the idea was that as many boats as possible would be turned straight back. However, if a boat were to come through that for whatever reason it could not be turned around, those people would be sent offshore. So in that third phase, there was a belief that these two policies were necessary in complement. However, since 2014, it was recognised that there actually is no role for offshore processing to play. Nobody new has been sent offshore since 2014. Instead, everybody approaching Australia by boat has been turned around or returned to where they came from. And there's been a gradual withdrawal and prolonged extraction from offshore processing since this time. So I just wanted to make that point at the bottom again to differentiate between the turning back of boats and offshore processing, because often the two policies are conflated, but they are distinct. And the argument has been made that if it is Operation Sovereign Borders, that is, if it is the turning back of boats, which has caused a reduction in the number of people trying to reach Australia by sea, then why do you need to maintain this very problematic policy over here of offshore processing? Why can you not just rely on it? So to touch briefly on our key findings, the first is that it did not deter irregular maritime migration. And this is really the reason why you pursue offshore processing. And as the numbers themselves show, it hasn't worked. So in that first year that offshore processing was reintroduced in 2012, you can see there's almost 17,000 people arriving by sea, and then in 2013, 20,000. If those figures are looked at by financial year, which more closely aligns with the first year of offshore processing from August 2012, we'll see that in the first 12 months of this policy, more people arrived in Australia by boat seeking asylum than at any other time in Australian history. And that number continued. It wasn't that all of those people arrived in the first few weeks and that then news trickled down of the policy and people stopped coming. People consistently arrived by boat throughout the first year. The numbers show that it really did not deter irregular migration by sea. And then it really wasn't until later on that we started to see the boat numbers start to drop, and that was after the introduction of Operation Sovereign Borders. Now, I should note, while this table shows that there were no boat arrivals really in 2014 and onwards, subsequent data from the government does show that there have been boats coming in 2014, 2015, 2016. However, nobody on those boats after sort of mid-2014 has been brought to Australia. Boats have approached Australia, they've been intercepted, and people have been returned to where they came from. Still, it must be noted that the number of boats coming did dramatically drop only after the introduction of Operation Sovereign Borders. There was no drop with the introduction of offshore processing. The second key finding is that this policy does not save lives at sea. And in many ways, this follows from the first. If we're seeing boat numbers increase, certainly not decrease, then it would follow that there would be a corresponding number of drownings occurring. And certainly when we look at the statistics of the number of people who drowned at sea, either in Australian waters or on approach to Australian waters from 2009, say, through to 2013, prior to Operation Sovereign Borders starting, there's a really comparable rate of death at sea in those years. From 2014 onwards, there has been a reduction in the death toll, certainly. And I think what this goes to, which is a slightly different point, but it's important to bear in mind, is that when we talk about deaths at sea and the humanitarian mission of wanting to prevent deaths at sea, we can't just think of the danger and the treachery in the ocean itself, or in smugglers perhaps putting people in non-seaworthy vessels. There is also a role that states play. And we see this not just in Australia, but all the time in the Mediterranean as well, that by delaying intercepting boats, by delaying intervening until the last possible moment, deaths can occur that way. So whereas previously perhaps there were instructions to delay approaching an asylum seeker vessel until it was very evidently in distress, that delay can cause deaths. And as I said, this has been seen in the Mediterranean as well. Whereas from 2014, when we had Operation Sovereign Borders, they were actively identifying, locating, intercepting vessels at the earliest opportunity, and then we see the death toll go down, which goes to show that active monitoring of this particular sea can result in a reduction in the death toll. And then the other part of the story is that if we look at the level of destruction of lives on land, it really undermines any claim that offshore processing is pursuing a humanitarian purpose. There have been deaths, and a number of them have been found by Australian coroners to have been preventable, and also serious harm inflicted on others. And some of that harm is detailed in our research, but it is also detailed more extensively by doctors, psychiatrists, social workers, and other health professionals consistently over a 7, 8, 9 year period. And it's evidenced by the number of people who have been medically evacuated to Australia. So in the table on the slide here, if we look at the column which says transferred after 19 July 2013, well, first, the people who were transferred in that first phase under the Gillard government, August 2012 to 19 July 2013. When there was the change in policy, they were all brought back to Australia and had to wait here, but were eventually able to apply again for asylum in Australia. So everybody in that first column, the 1,055 people, yes, they went offshore, but they then got brought back to Australia when there was a policy change. The detention centres were emptied, and then they were refilled by people arriving after 19 July 2013. So just over 3,000 people were sent offshore since the policy change in July 2013. And if we look at those numbers as of the beginning of this year, more than 1,000 were back in Australia having been medically evacuated because they needed urgent and critical physical and or psychological mental treatment and assessment. So huge numbers of people were medically evacuated back to Australia, and less than 300 people remained offshore. So as of today, in terms of the cohort of people who are still subject to this policy, the vast majority are actually in Australia receiving medical treatment because of the level of physical and psychological harm they've suffered over so many years offshore. Our third finding is that this did not break the business model of people smugglers. Again, it did not stop boats. But at a more deeper and fundamental level, the issue is that focusing on trying to crush smuggling networks misdirects attention from the root of the problem, which is an assessment of who in our region is in need of protection. Where might they find that protection and how can they reach it? And so by focusing so squarely on trying to close off avenues to Australia, rather than trying to create and expand strategic, safe and legal pathways to protection. By focusing on that closing of the border, Australia is actually feeding rather than removing the demand for smugglers' services because people have no other option. They're not given any other choices. There's also an important point to be made, which is that the idea of people smugglers as evil, as scum of the earth, and this is the language that we often hear invoked across the political spectrum in Australia to describe smugglers. It's an oversimplistic narrative of smuggling. The reality can be very different. Yes, certainly there can be egregious crimes that take place, but smuggling is simply a response to border policies. We've seen this, we can see this with Afghanistan and developments in Afghanistan over the past few weeks. When events occur in someone's country which force them to flee, and the few safe and legal pathways out are blocked. So in that case, it was that most people couldn't get into Kabul airport, or they could get into Kabul airport, but they couldn't get on a plane. What other choice do they have to get to safety? Many people will be forced to rely on smugglers to get to safety. And certainly when we're reflecting on these issues with European countries now showing interest in offshore processing, Europe has its own particular history with smugglers, particularly around World War II, that smugglers really saved people's lives. Smugglers can be a lifeline for those who are otherwise trapped in harm's way. So we just need to nuance that a little bit. Yes, there are terrible criminal elements in the smuggling world, but to see smuggling as something which needs to be attacked by government policy, as opposed to something which has sprung up in response to government policy, is a bit short-sighted and limits us in the way that we can address these issues. And finally, this idea of breaking the business model of smugglers, it's attractive, you would think that it would garner support, it's simple, it's catchy, but it doesn't correspond with the reality of displacement. And wide-scale studies have shown that there is no single business model of smugglers. There are multiple business models, and there is no one strategy or immigration policy which is going to address all of those different models. So it's a catchy slogan. It's certainly taken off, but it doesn't correspond with the reality either of displacement or of smuggling networks themselves. So we had some other findings as well. Those findings were speaking to the stated policy objectives. But moving beyond that, we wanted to look at other indications of policy success or failure. And there really is unjustifiable financial expense. And there's no dispute on this. I mean, if we're looking at the costs, and these are taken from government figures, actual cost year on year, we're seeing hovering at or above the $1 billion mark on average. And I should say that is an extremely conservative estimate, because these figures do not include substantial costs. We've written a long list of costs which we don't think are actually included in those figures. So the real cost, it would appear, is significantly more than $1 billion a year. But even if it was just sitting at that, that is a huge amount of money for what is effectively now less than 1,500 people, most of whom are in Australia anyway. And it's a huge amount of money for a policy which isn't achieving what it was supposed to do. The other issue is not just the sheer cost, which we're seeing in that actual cost column at the end there on the right, but also the difficulty in predicting the costs of a policy like this. If we look sort of 2, 3, 4 years prior, the government was consistently expecting the cost to drop, and yet they remain high. And what this means is not just that this policy is expensive, but also that the expenses are incredibly difficult to predict. And that makes it a difficult policy to implement and budget for. Some of our other findings include that it fails to comply with fundamental rules of international law, and this has been well covered by many, including every single UN expert and body which has reviewed Australia's policy. They have all of them consistently noted shortcomings in terms of compliance with Australia's obligations. There are critical legal challenges in domestic Australian courts, in Nauru and PNG courts, multiple referrals to the International Criminal Court, and challenges within the UN human rights system. And then systemic cruelty. And we call it systemic. It is not just incidental. It is not an accidental part of the policy. Australia has been on notice about the significant and escalating harm of this policy since its inception. The physical and psychological harm has been a direct result of government policy. And Australia at all times had the authority and capacity to remove people from harm's way, but chose not to do so because it was trying to pursue this deterrent objective. So they were our key findings, and I'm very happy to speak to them further in the Q&A. But where they brought us to in terms of our recommendations and overall findings was that this so-called Australian model of offshore processing is a policy failure in that it doesn't achieve the 3 key things it set out to achieve. At the same time, it's involved enormous financial costs for Australian taxpayers. It's implemented contrary to the fundamental rules of international law. It's triggered legal challenges. It's systemically cruel. And for all of these reasons, it's considered a policy failure. And off the back of that, our recommendation was that this policy should be immediately brought to a formal end and should not be adopted or picked up or used as inspiration either in other jurisdictions, particularly in Europe, nor in the future in Australia. Once this finally is wound down and the final sort of 1,000 people are given a resolution to their status, we should never again see a third iteration of this policy, because it simply is not an effective, sustainable, humane or lawful way of addressing the very real migration challenges that the world is facing at the moment. So thank
Madeline,
you.
Thank you. Thank you very much indeed. Very, very thoughtful, fascinating address. We now have half an hour for questions and discussion. Please feed in your questions if you haven't already, using the Q&A function at the bottom of your Zoom screen. And our question moderator will feed the questions to Madeline.
Fantastic. Thank you to everyone who submitted questions so far. We might begin firstly with this question. Do you think that the interest in offshore processing in the UK and Denmark will spur interest in policy in other European states as a sort of domino effect?
That's certainly the concern. So when we raise our concerns with these European jurisdictions who are considering offshore processing, primarily we want to ensure that what they've been sold is the truth. And we are concerned when we speak to them, we can see that they've been given an impression of offshore processing which doesn't actually match the Australian reality. So the first task is to try and sort of debunk some of the misinformation and the myths that exist around it. The second thing is to try and address that fear of the domino effect, because what happens next? Denmark is a relatively small country and they receive a relatively small number of people arriving spontaneously at their border. But should Sweden and Germany and France and one by one all of the other countries adopt a similar policy, not necessarily because they want to from a political or ideological perspective, but because they are forced to because if every other country is starting to push the burden onto the one next door, the pressure will get too much and they'll have to push it on further as well. Then where does it end? The whole system may collapse. And, as much as it's sometimes put that particularly us refugee lawyers are, trying to maintain the system purely for humanitarian reasons, in fact, the contrary is true. There is a strong state interest in maintaining the international refugee law system because it provides a framework, an agreed common communal framework with structured processes through which we can attempt to manage at least some of the displacement that we're seeing in the world. But it relies on everyone, meeting their obligations in good faith. And if states gradually start to pull out, then really it is chaos that will result. So for those who are advocating for, well-managed, strong state systems to keep these things, well-managed, then there is an interest in everybody sticking to the plan. And as soon as one goes, others might follow.
Following on from that, our next question is, do you think the European Charter of Human Rights will prevent European states from implementing this policy?
Yes, thank you, Nathan. It's absolutely a critical issue, and it is why there is a distinction between Australia and our international partners, because Australia has no binding human rights framework, neither domestically nor regionally. And that is the main reason why this policy has been able to continue as long as it has. It is very difficult to see how this policy will be able to be implemented within the binding frameworks, the human rights frameworks which exist in Europe. That's not to say that governments won't try, though, and they might try to sort of pick and choose aspects of the Australian model and leave out those which more blatantly violate human rights obligations. The result then is a policy which could just be chopped and changed so much that it really is incoherent. Whether that results in something which is effective or not remains to be seen.
Fantastic. Our next question goes to Operation Sovereign Borders, and it asks, refugee advocates seem wedded to dismantling the whole system, justified because it's inhumane. However, what are your views on maintaining Operation Sovereign Borders but not offshore processing? If this means the government can be convinced to drastically increase annual refugee quotas while still appealing to those who believe the national security spin?
Yeah, thank you for that question, Trudy. Look, it is true that this is an area of policy and law which is deeply divided, and those divisions are not sustainable, and they're also very problematic. They're not productive. So I always caution when people sort of categorize, refugee advocates versus government versus left versus right, pragmatist, idealist. These categories aren't always incredibly helpful because, in my experience at least, I've spoken with people across the spectrum from all walks of life with a range of views more broadly on what the country should be doing in terms of immigration. But they can share a similar basic concern with doing something which is not grossly inhumane. I'm yet to speak to anyone who very proudly advocates that we should be openly and outrageously cruel. So I think the concern with being humane is shared across the spectrum. But there is that question of, dismantling the whole system, dismantling some of the system. Absolutely not in favour of dismantling the whole system, whatever the whole system might be. The purpose of this research was to say this is one aspect off here in the corner, which has proven to be not fit for purpose, and it needs to be torn away and put aside and not returned to. Then we can turn to Operation Sovereign Borders and say, what do we do about the boats? Certainly in the short term, I can see the value in the views that have been put forward to say that if you maintain Operation Sovereign Borders without offshore processing, that allows the government to sort of continue the naval ring of steel around the country, to maintain sort of control over the border in the way that it wants to do so. And so that would allow you to dismantle offshore processing. Look, I do have longer term problems with offshore Operation Sovereign Borders as well. I don't see it as a sustainable policy. As I mentioned about Afghanistan earlier, we're seeing hundreds of thousands of people are estimated to be fleeing out of Afghanistan in the coming weeks and months, people who did not manage to get onto planes and evacuation flights, etc. Now, there is a very high likelihood that some of those people will end up on boats to Australia. And amongst the people on those boats may be, former Australian employees, Afghans that worked alongside Australians as interpreters, as security guards, There could be, many incredibly impressive people who've achieved great things in Afghanistan but have now been forced to flee. I'm not convinced that the best and most sustainable response to those people coming by boat would be to just push them back to Indonesia and say they're not our problem. And that's what Operation Sovereign Borders would currently require. I actually think that a more nuanced and flexible and agile approach needs to be taken. I would say that Australia needs to recognise there are these large flows of people coming out of Afghanistan, recognise that we have obligations to a significant number of those who didn't manage to get into the airport and onto our flights, and to be increasing our resettlement of those. I think that reorienting our policies towards, expanding resettlement programs and things like that is a more effective way of reducing the number of people who need to risk their lives on a boat. But certainly in the short term, I would think that offshore processing needs to be immediately closed down. And then in due course, we can turn to Operation Sovereign Borders. But in terms of the argument that Operation Sovereign Borders could be maintained, and then as a result, the government could be encouraged to be more humane in other areas of its policy, that has not been the practice. We have had Operation Sovereign Borders, and at the same time, we have reduced our resettlement quotas, and we have actually stopped resettlement altogether from Indonesia. So if an asylum seeker, if a refugee now comes to Indonesia, they will not be able to be resettled on a plane through a UNHCR process to Australia. They just don't have that option. So I like the idea behind it, but it just is not reality. The reality is we have Operation Sovereign Borders, and we are also scaling back the other safe and lawful pathways.
Great. Our next question asks if you can comment on the Malaysian solution.
Thank you, Philip. So the Malaysian solution was a policy proposed by Julia Gillard in 2011, which would have involved Australia returning a certain number of asylum seekers who arrived in Australia by boat to Malaysia, and in return, resettling an even larger number of people who've been recognised as refugees from Malaysia, so flying them in by plane, sort of a people swap arrangement. That deal was, struck down at the last minute. I think the plane was literally on the tarmac ready to take off when the order came down, halting the deportation of the first cohort of people back to Malaysia. It didn't take off. And what followed after the aborted attempt at the Malaysia solution was 12 months of political impasse, where the Abbott opposition basically blocked every move that was put up by the government. The Gillard government refused to cave to the Abbott government's requests, and nothing got done. And it's an example of where the national interest was obstructed by the political games, because neither party could agree on a communal way forward. And in the meantime, we saw, as you'll see from the charts earlier, the number of people arriving by boat continuing to increase. So the Malaysian solution wasn't permitted under Australian law as it stood at that time. It is an interesting idea that has been floated around by others as well, that idea of flying people back to Asia as a way of discouraging them from having come by boat. Where that falls down, and it's a similar answer, I guess, to the question I had earlier from Trudy, where it falls down is it presumes that there are safe and lawful pathways for people to take to reach Australia. All of these deterrence policies presume that people have chosen a boat rather than some other option, which was the right option. The reality is, for most people displaced in our region, they cannot claim asylum in any other country because there is no other refugee convention state which they pass through. And there is no, there is no safe and lawful pathway available to them. There's nowhere they can go to apply for a visa and wait to be flown on a plane to Australia through resettlement. So as I said, there are aspects of that which continue to get attention, but the concern is always, if Australia really wants to address this, it needs to create those safe and lawful pathways.
For our next question, I might combine two questions here because I have a feeling they'll be interrelated. The first is, what is the policy of the EU regarding, for example, those arriving from North America or into Lithuania from Belarus? And the second is, why are some countries that you mentioned beginning to look at this policy and look to Australia now?
Thank you. So an issue that Europe has been facing really since 2015. Beg your pardon. It's not COVID, but it is a nasty cough. Europe has the most advanced and developed regional refugee framework in the world, the Common European Asylum System, that has been developed over several decades. But in 2015, it collapsed under the pressure of Syria, Libya, various conflicts in Africa. A series of developments occurred. And even though that system had procedures built into it, which should have been triggered for sort of mass influx and temporary arrangements, instead, Europe went the other way, and many countries closed their borders. Many other countries were overrun. So we saw, Greece and Italy in particular taking huge numbers of people, more than they could manage, and disproportionate balancing of people throughout European countries. Really, it feels like Europe has been on the run since then, sort of scrambling to come up with a new European approach to arrivals, particularly those coming across the Mediterranean and across the Aegean through Turkey. Part of perhaps the interest in what Australia has to offer is that it's been touted as, we succeeded, we stopped the boats coming, and we've got this policy that we've found. And so when you're looking at a region which is struggling to work out what to do, and another country says, look, we've got this solution, why don't you try it out? It's not surprising that there's interest in what Australia has done. However, the biggest concern, or one of the biggest concerns, is the issue of scale. So at its maximum, no detention centre in Nauru or Papua New Guinea ever had more than about 1,500 people. In total, I think it peaked across both places at sort of 2,500 people. That was the maximum we ever were processing offshore. And even then, we saw the figures that cost us. And the systems really collapsed in terms of processing and service provision. So if we're saying the Australian policy, which I'm saying was not a success anyway, but the Australian policy was looking at 2,500 people. Greece was getting that in a morning at the peak of its crisis. In one morning, it would get the total number that we had, all together across both places over the course of a year. So if they're talking 100,000 people, 200,000 people, we would have concern that this model that we've done in Australia has never been scaled to that level. And probably they need a deeper solution just because of the sheer numbers.
Okay. Our next question regards the ICC. You mentioned that the issue has been referred to the International Criminal Court several times. Given that most UN experts agree that the policy may be in contravention of human rights conventions, what was the opinion of the ICC? Or I guess if we broaden it out, other international courts and bodies that have reviewed the policy as well?
Thank you. So there is broad consensus across all of the UN experts, really, that fundamental concerns with the policy include that it violates the fundamental prohibition on non-refoulement. That's the prohibition on returning people to a place where they would face persecution or serious human rights violations. It has been found to amount to cruel, inhuman, degrading treatment, potentially even torture in some cases, has been some suggestion. The issue that the International Criminal Court was looking at was whether it amounted to crimes against humanity. And so there's been 6 referrals by independent experts, and they're not just sort of from Australia. We've got an Australian politician there, but you've also got some of the most eminent legal minds internationally from the United States and Europe and elsewhere have referred Australia to the International Criminal Court for crimes against humanity. To date, the way that the Office of the Prosecutor has responded to those referrals is to agree that certain aspects of the conduct do amount to violations of fundamental rules of international law, and the Office of the Prosecutor has identified those quite particularly. But in terms of the question of whether it rises to the level of a crime against humanity that would be prosecuted by the ICC, that's another level and another question aside, and that has not yet been accepted on that basis. But the fact alone that we're being referred so often, 6 times in a 3 or 4 year period, so often to a court which traditionally we would associate with, war crimes, genocide, really the most horrific and barbaric crimes that could occur in the world, to be continually referred there by, international leading jurists, should be a very real cause for concern.
Great. I would remind everyone that if you want to submit further questions, feel free to do so via the Q&A function that you'll find at the bottom of your screen. Our next question is, to what extent do you think the introduction of the Rudd Labor government's no resettlement policy was influenced by political pressures given the then imminent September 2013 election?
Yeah, absolutely. It's a consistent pattern that no good immigration policy is made in the lead up to a federal election. It's too much of a hot button issue. It's too easy to invoke immigration one way or another. And policy always takes a slide. The 2013 election was particularly nasty. It was not necessarily a very evidence or fact-based series of claims that were made in terms of immigration. So I think definitely the fact of it being an election year, the fact of Prime Minister Rudd having just assumed again the leadership a few months out from the election, there was a lot of political turmoil at the top there. I think that did play into it. When the no resettlement policy was introduced, I think it relied perhaps too heavily on his personal relationship with the Prime Minister of Papua New Guinea at that time. And perhaps if Kevin Rudd had stayed in power, then maybe something could have been worked out. But the reality was that I think it was an idea created between the two of them. It sounded good at the time, but it just didn't pan out in reality. And if they had listened to UNHCR, they would have known that, because UNHCR, who are the experts in this area, who have been working in Papua New Guinea for a very long time on this issue, had consistently written to them and said, this won't work because of the various reasons, including the socio makeup of the societies in these countries, the cultural makeup of societies in Nauru and Papua New Guinea. It's not going to be easy to settle non-Melanesian refugees into these communities for a whole lot of reasons. This isn't going to work. They're not multicultural countries like Australia, which are used to welcoming in people from all over the world, from diverse cultures and religions and backgrounds. This will be a huge challenge. And they didn't see how it was feasible. And all of the concerns that UNHCR detailed very precisely all came to pass. It was a prediction, all of which came true. So it was a policy that, it was obvious it was not going to work, but really we can trace a lot of the issues we have with this policy back to then. Because if we had the policy settings under Howard, which was that once found to be a refugee, people were settled back in Australia or some to New Zealand or some elsewhere, this policy would have been done by now. We haven't sent someone there in a very long time. The people who were sent there in 2000, 2014, 2013, 2014, they would have been processed. Those found not to be entitled to protection would have been returned to their countries of origin. Those found to be refugees would have been settled largely in Australia. And this would be behind us by now. We would not still be talking about it. And we certainly would not be sinking billions of dollars into it. But because Rudd decided in 2013 to say, no settlement in Australia, and then the incoming Abbott government was going to back that in. Once somebody's gone hard, you can't unwind that. So they continued to back in that policy. And I can see further down, there's a question, thank you, Caitlin, about whether there's any acknowledgement within the government and policymakers of this being a flawed policy. We've seen that already from about 2018. Peter Dutton, who was the Home Affairs Minister at that time, really shifted the language. It went from offshore processing is this great thing that we're supporting and that we're overseeing to this was Labor's mess. We didn't start offshore processing again. We didn't want this. We're trying to get people off these islands. So already we've had a few years now where there's been a radical shift in government positioning on offshore processing, from it being a positive thing, which they were overseeing a huge expansion of, to, this is Labor's mess. I didn't want this. I didn't put people there. I'm just trying to get out of it.
Okay. Our next question asks whether you can explain how Australia can continue to not offer protection to refugees and asylum seekers when Australia has signed up to international conventions on human rights. Is it the case that domestic law trumps international law?
Yes, that depends on who you're talking to. If you had a domestic lawyer and an international lawyer in the room, they would both claim that their law is the trump. That's really the issue. International law in the areas of human rights and refugees depends on states acting as responsible international citizens. I often liken it to, states aren't treated as the naughty teenager who needs their parent to come in and discipline them when they do the wrong thing. That's not how the system works. We're presumed to be full-grown adults that can, conduct ourselves in their own appropriate way. So states have complete free will or sovereignty to choose which obligations they do and do not sign up to. Australia chose to sign up to the International Refugee Convention and other key human rights treaties. And that wasn't just one thing that we did historically, it's something we've continued to back in. We continue to hold ourselves out as a leading international citizen when it comes to these issues. The way that then the UN bodies like UNHCR work is that their role is to help states identify when their policies have fallen out of line with their obligations. And then it is expected that a liberal democracy like Australia, having been alerted to the fact that its policy was out of line, would bring it back into step with what's expected. It's not a situation where we're going to get sanctions put upon us, or we're going to have UN peacekeeping troops, march on Australia because we've done the wrong thing. The system depends on states doing the right thing and being international citizens. In terms of why the Refugee Convention can't be invoked before an Australian court, the issue is that there are two ways for international law to be incorporated within a state's domestic law. Some states have a system whereby the moment they've signed the international treaty, it automatically becomes binding domestic law. But Australia has the other system, whereby the first step is that the government signs the treaty, and then the second step is the parliament needs to enact legislation, which brings it into Australian law. And the problem is we haven't done that. Our legislation has not brought into Australian law the commitments we've made at the international level. So that's how we get that disconnect between being bound by something internationally, but having no enforceable basis at the domestic level.
Our next question is, during the Bangladesh Liberation War, we had about 6 million refugees cross over the country's border and enter Kolkata, effectively almost doubling the city's population. After the war was over and Bangladesh was formed, most, apart from about 500,000 people, returned to their homeland. The questioner says that they're a great supporter of refugees and their rights, but cannot help but notice that when they come to a country like Australia with all the benefits, apart from a small handful, very few of them return to their home countries even after the danger has passed. That appears to indicate that many of them are economic refugees. So would you agree that at least some of those fleeing persecution should return home after the danger has passed?
Many do. People do, come to a country like Australia if they're entitled to under former systems. They might be granted permanent protection. In time, they might become Australian citizens. And then if there is a change back in their home country, they might return and, either return to stay or be back between Australia and that country. Sorry, I just realised I was muted.
We got the first bit of that.
Oh, right. Okay. So this needs to be seen as an issue of broader social policy, and this will be different in every country. So thank you for that example. I can't speak to that context. But in terms of the Australian context, there is a real issue with keeping people on temporary visas, which is what we do. Rolling 3-year visas where they need to reprove every 3 years that it's still a danger to go home. The public policy reasons why such visas should, I would say, be abandoned is that they have been shown to create very high levels of insecurity when it comes to employment, when it comes to engagement with the community, engagement with the economy, individual growth, community growth, all the rest of it. Both for the individual people and families, but also for the Australian communities who are benefiting from having these people amongst us. There are strong positive reasons to formalise the connection between the newest arrivals in our country and our communities through permanent pathways eventually to citizenship. So there might be a case for certain groups for saying that maybe, we'll get you in quickly, particularly if a war has just broken out. Let's get you straight in and put you straight onto a 3-year visa. Let's get you here faster out of harm's way into safety for 3 years, and then let's reassess in 3 years. And if the conditions of harm are still there, then we can transfer you to a permanent visa. But a lifetime of rolling permanent visas are incredibly destructive. like I said, for the individual person, for the community, for the economy, for all sorts of reasons. It's better to have people putting down roots, buying property, going to school, getting jobs, all of these types of things. It's just better for everybody.
Our next question asked, what were the biggest expenses in relation to offshore processing?
Yeah, thank you. So the biggest expenses, and I think I saw another one about costs earlier, the biggest expenses really are going to private companies which have been contracted to, build, run, operate, and provide services in the detention centres, and now to the few hundred who are living in the community. That's where the big expenses have gone, into the pockets of a few companies, and a big issue of tension, I have to say, particularly with the local people in Nauru and in Papua New Guinea, is that so much of that money went to Australian companies and not to local companies. So, they're the ones that have in many ways borne the brunt of the detention centres and environmental damage and all the rest of it, and being sort of economically exploited in terms of low wages that they're paid, while the big bucks go back to Australian companies. And it's really something that is worth looking into a bit deeper, because when we talk about why this policy has been maintained so long, despite not meeting its stated policy aims, it would appear that a significant reason is that there are big companies with financial interests in keeping this policy on foot. A question I saw earlier, which is what are some of the costs which are not included? And they're huge. The legal challenges, it doesn't appear that they are included. And when I talk about legal challenges, that includes one which the Australian government had to settle for $70 million, plus $20 million in legal costs. So that's almost $90 million to settle a claim. And that's just one of many. So the costs are huge, and they are not included in those figures of $1 billion. Also, what doesn't appear to be included in the cost of $1 billion is all of the costs associated with the people who are actually back in Australia. So if you recall that we've got more than 1,000 people back in Australia and only maybe 200 people offshore, that $1 billion is just for the 200 people offshore. There's then a whole another range of costs that go to the 1,000 or so people who are in Australia. And when we talk about costs, it's also important to have comparisons and to bear in mind that modelling has been done to show just how much Australia would save, just how much cheaper it would have been to have people on bridging visas in the community rather than in detention in another country. And the savings would have been phenomenal.
I think we've got time for a question.
Yes, final question for tonight. A final question is, in regards to the findings of your report, how might the Australian community best take this information to advocate for the rights of refugees and asylum seekers? In your opinion, what is the most effective way of advocating for a change in regards to this issue?
Thanks, May. That's a really interesting question. And we go back and forth on this. I mean, the Kaldor Centre was established with the mission, with a mandate to feed in high quality evidence-based research into the immigration debate in this country. The concern was that it was becoming so toxic and so divisive. Sides have been drawn and people have those views no matter what. That it was thought that if we could feed in, sort of a more neutral evidence base to the discussion, that what would follow would be good policy. Now, there is an important role for evidence-based research to play. However, that on its own doesn't change hearts and minds. And I think the most effective means of advocating for change is returning to the human story. We've seen this with the Biloela family, with certain other families. Australians rally around causes which they say, look, I don't know necessarily what the answer is for the big issues about immigration, but I do know that something about this story isn't sitting right with me. It's not right for me that my country is, treating children in this way or separating families. It's not right that you've got a husband stuck on Manus Island who can't get to his wife and children who are living in the community in Sydney. Something about that doesn't make sense to me. So I think the most effective way is to bring those human stories into it. Remind us of stories that we can relate to in our own lives and families. The issue, though, is, and it's part of the issue with offshore processing and detention, all the rest of it, is that these policies keep people out of sight, out of mind. They are concepts, the concept of people coming by boat, rather than humans that have a face and a name and a story. So I think the more that we can try and break that down, the more that we can make some change. And just remembering that really Australia's history has shown us, this isn't just a broad claim, our history has shown us that we are a much richer nation, economically, but also socially and culturally and in terms of development, for having people come in from different places and bring their skills, bring their knowledge, and bring that, and for Australia to benefit from that. So I think that's another important point that we might bear front of mind.
Thank you, Madeline, and thanks to everyone for a very interesting range of questions. We'll be having a further event in 2 weeks' time about dying democracies in the world with Professor John Keane from Sydney University and a prominent Indian journalist, Devadish Roy Chaudhary. Do join us for that. And in the intervening week, we'll be publishing columns from Glover Colleges with our recommended readings. But to round off tonight, I'd like to invite one of our interns, Isabel Freudenstein, to move a vote of thanks.
On behalf of the New South Wales branch of the Australian Institute of International Affairs, I'd like to thank Madeline for such an engaging assessment of offshore detention, 9 years on from its reintroduction. We were so lucky to hear from an expert in the area on a topic that is an ongoing issue for Australia and one with such global implications. Thank you for outlining your research into the failures of offshore detention in its inability to achieve its 3 key policy objectives, not to mention the massive humanitarian and financial costs. Thank you again, Madeline.
Thank you for having me, and thank you all for the questions and for allowing the discussion to continue.